those were, and I think that those were probably put there by the children, the students at Sherman Indian School. The reason I bring up the matter of the children that perished at the various boarding schools, and by the way, there were 350 boarding schools across the United States. And if there was a similar death toll at each one of them, such as at Sherman with 70, that would be more than 20,000 students, more than 20,000 children, kidnapped children that were stolen from their families, that were put into those institutions, genocidal institutions, to destroy our languages, cultures, and spiritual traditions. And so I think that I wanted to bring that up to frame and contextualize this conversation today with regard to the doctrine of Christian discovery and domination. Those grave sites are the perfect symbol and representation of the unknown caller. If people could please mute themselves, that would really be wonderful. And thank you so much. I really appreciate it. And so those graves and those children who were sacrificed by the system of domination are a perfect representation, a perfect example of the domination and dehumanization of our nations and peoples. And the documents that we're using to talk about the doctrine of Christian discovery and domination are Vatican papal documents from the 15th century, royal charters of England, and so forth, that have in the Latin language versions of them the patterns that I'm talking about. Now, I wanted to bring up Tamara Starblanket's book, Suffer the Little Children, Genocide, Indigenous Nations, and the Canadian State, that was published in 2018. And Tamara does a wonderful job of applying the framework of domination and dehumanization in her book. And the what I'm attempting to talk about here is the identification of a system. And it's a system that hides itself through euphemisms, nicer sounding words than domination, euphemisms such as civilization, state, sovereignty, ascendancy, dominion, property, and empire. Those are 7 of those terms of domination. And the Canadian state, the state of the United States, and the various states of the United States, the provinces of Canada, the legal and political experts that maintain those institutions have a very unique skill set of being able to use that language of domination while making it appear as if they're not doing that, because they're using these other terms. So when I have developed something I call the Domination Translator, and it's actually a simple technique. You take examples of domination where you see them, and then you place that in the text through brackets, the use of brackets. And then you might have a paragraph where you look at the language in a given paragraph, you read that, and then if you were the average person, you would just read the words and you would comprehend them in a certain way. But when you put the domination terminology in there in brackets, every time you see a word of domination, suddenly what's in the background is in the foreground. And then you can be very consciously aware of that. And so you could do this with all kinds of documents. If you did that with the UN Declaration on the Rights of Indigenous Peoples, you would put the word dominated after the word indigenous, because that's the definition of indigenous in the United Nations framework. Within their working definition, there's actually a couple of them, but they're saying that the indigenous peoples, or the indigenous, quote unquote, are those descendants, the descendants of the peoples not the actual peoples, but merely the descendants of those peoples that were existing in a particular place when a secondary population came in and through conquest, settlement, and other means established dominance over them. So the right there in the definition, the dominance is dominated, or domination in that case, and established domination over them would be the way to put that. Through conquest, that's another word of domination. Settlement, that's another word of domination. And pretty soon, if you keep doing this technique, you'll see that it's domination, 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 repeated over and over and over again, but nobody notices because they're using synonyms, other words for domination that are not understood with that meaning or not understood with that definition. If, for example, you take the word civilization and you look it up in the Webster's Third New International Dictionary, you'll find that one of the definitions, one of the entries is the forcing of a particular cultural pattern on a population to which it is foreign. That's a process of domination, that forcing of that cultural pattern of domination on that free and independent nation or people. So the context, the initial context for all of our nations and peoples is an original, free, and independent existence before any of the colonizers came by ship across the ocean carrying their mindset, their mentality, their worldview, and their system of domination with them that they were going to use to assume and claim that they had the right to control everyone and everything wherever they landed. Now the the documents of the papal bulls, I'm laughing because my dad's sweeping he's sweeping out back and his dog is barking, so it's throwing me off a bit. But in those documents from the papal bulls, you see these patterns of domination in the language. So as an example, and I'm sure many of you have heard this a number of times, but in the papal bull of 1452, the Dum Diversus, which was language repeated in the next papal bull of 1455, the Romanus Pontifex, you have language that says that the King of Portugal is authorized by the Pope to go to the western coast of Africa and to invade, capture, vanquish, and subdue all Saracens, pagans, and other enemies of Christ, to reduce their persons to perpetual slavery, and to take away all their possessions and property. So if you use the Domination Translator on that text, invade is domination, capture is domination, vanquish is domination, subdue is domination, reduce to perpetual slavery is domination, and take away all the possessions and property is domination. So you have all those instances right there in that one document of that pattern. You also have a sentence in the papal bull of May 4th, 1493, that says, we trust in him or have confidence in him, from whom, now him has a capital H on it, by the way, so that's talking about referencing their deity, from whom, meaning out of whom, empires and dominations, dominationis in Latin, and all good things proceed. So their deity, they see that deity in those papal bulls as the theological being, the God, to use their language, from which their claim of right of domination issues forth. And then all the good things that come with empire and domination. If you're able to exploit an entire continent or entire hemisphere and take the children and destroy the languages, culture, spiritual traditions, do everything you can to take those nations and peoples that are already existing there in a free and independent existence and take them apart at the seams, then you don't have any competition for quote unquote resources. And so you can just keep going with all these various documents and look at the court rulings and so forth, and you'll see the same thing being used over and over again. But the lawyers aren't taught what I'm telling you today. They're not taught this in law schools. They don't have any consciousness or awareness of this. Even the scholars that have studied a lot of these Vatican documents and so forth, they haven't really gone into them in detail in the Latin language and understood the true meaning in my view, of what those documents are and what they perpetuate in terms of an ongoing destructive domination system. Part of the problem with this is that you end up repeating the word domination so many times that has a mind-numbing effect, and like, oh my God, again, you know. But that's just one of the challenges that we face, because one of the first rules in writing is don't repeat yourself. Once you've said something, move on. Well, that's a perfect formula for never coming across this information or being able to explain it, because once I said it one time, that's good enough, and then I'll move on and it'll never be discussed again. So we can't give in to that. We have to kind of put up with the repetitive nature of this explanation, despite whatever frustration we might experience as a result of that. There's another sentence in the Papal Bull from May 3rd, 1493. It's in Latin, and it is que sub actuale dominio temporale alicorum dominorum Christianorum constitute non essent. And what that means is lands that are not established under the domination, dominio, of any Christian dominators, dominorum Christianorum. And so what that means, that the intention that they all had when they set sail was to go and locate those places throughout the planet, across the planet, that did not yet have their system of domination imposed in that location. Then they could claim, they put up a flag or pile up some stones or do some kind of ritual, supposedly baptize the land, look for a river, the mouth of a large river, and then claim that river all the way to its source, and all of the waterways that extend from that river. And then, according to the rules that they lived by, which was the honor among thieves rule, then they were able to claim that area, and then all other latecomers would not be able to lay claim to that area, meaning claiming a right of domination over that area. The other thing too is that there are a set of arguments, a set of principles that can be used to oppose this system that I'm explaining. And one of those is first in time, first in right. Each and every one of our nations is the original nation of our traditional area. And so the people that came across the ocean, they are not first in time, first in right. Although from their viewpoint, they are, because they're first ahead of all the others from their part of the world. But that's not what we're referring to here. We're referring to this way in which we can challenge their presumptions, their assumptions, their presuppositions, and that sort of thing. So, first, if you could please mute yourselves, that would be really wonderful. Thank you so much. And so the second one is void ab initio nemo dare quod non habet, which means void when initiated. You cannot grant what you don't possess. None of those monarchs, none of the popes had any jurisdiction, rightful jurisdiction, valid jurisdiction outside of their realm or outside of their domain in Western Europe. They certainly had no rightful jurisdiction or valid jurisdiction across the ocean. And so their documents purporting to have any rightful authority anywhere else in the world were null and void at the time they issued them, or they were certainly null and void at the point when their ships reached the territorial waters of any coastal original nations. And so that is a powerful argument to use against them. And then you also have anything that is wrong from the beginning can never be made right because it was wrong from its inception. And that was created by Western Shoshone elder Glenn Wasson. And it's such a powerful formula. Now, I'm saying these things because what I'm suggesting here is that when we're looking at these various documents, such as the UN Declaration and so forth, or maybe Article 46, and the claim that no one can legitimately question their right of territorial integrity, their claim, we should say, of their territorial integrity and so forth. Even that word territory in their context comes from a Latin term, terreo, meaning to hold a place in subjection through terror. And certainly when we look back at the history, we see their use of terroristic techniques to establish their claim of a right of domination wherever they have gone. And so then they say, oh, we have now the right of territory, but that sounds like just kind of ordinary, because we even say, many of us talk about our various territories, but we're not meaning it in that way. It's in a different context that we're using that term. But in any case, looking at those documents, such as the UN Declaration on the Rights of Indigenous Peoples, it's my view that we need to come at this in a more systematic manner in terms of examining the deeper intricacies, the deeper subtleties of their language system and their techniques of domination, so that we can begin to respond to those by using that name, by correctly naming their system as a system of domination based on the documentation that we have compiled and accumulated over decades. Certainly the, preliminary study on the Doctrine of Discovery back in, I didn't mean to be sitting that close to the screen there, back in 2010, that we submitted to the UN Permanent Forum on Indigenous Issues, and that Tanya Ganella Fishner presented there as the North American representative to the Permanent Forum. That was a starting point, and then the following year we had the conference room paper. So we were doing, I think, a pretty good job of beginning to provide an explanation of this in a more systematic way, but it was never really followed up on. And it just, there were a number of reasons for that. So I guess what I'm suggesting here is that maybe there's a way in which we can become more effective. I'm certainly looking for ways that I can become more effective in getting the information out and explaining a lot of this. There was just a Supreme Court ruling that was handed down yesterday, United States versus Cooley, I believe it is. And when you look at the language in that ruling, it's so interesting because it sounds so kind of innocuous and legalistic, and in terms of how the court is explaining their position in coming to their conclusion. But one of the citations that they provide is Oliphant, the Oliphant decision of 1987, I believe it is, and Chief Justice Rehnquist. Now, what's really interesting about that, and I'll explain why I'm going to talk about this, is what I'm about to explain is how these titles of cases become the replacement for any examination of the reasoning process that went into the prior decision. So all they have to do is mention the title, and then they don't have to revisit any of the reasoning process that went into that. If you could please mute yourselves, that'd be wonderful. Appreciate it so much. And so in this particular case, they just use that title, Oliphant, and they don't go into the specifics. But when you do go into the specifics, what's interesting is that Chief Justice Rehnquist took a sentence from the Johnson versus McIntosh ruling of 1823, which is the first ruling that really used the doctrine of Christian discovery and domination in U.S. federal Indian law, a decision that's also used in Canadian law and other places on the planet. But he took this sentence, which was talking about their rights to complete sovereignty as independent nations were necessarily diminished by the original fundamental principle that discovery gave title to those who made it. So he took that sentence and he changed it to read, their rights to complete sovereignty as independent nations are, he took the word were out and he replaced it with the word are present tense, and put that in brackets, necessarily diminished, and then he put a period after diminished and closed the quotation marks right there. So he left off by the original fundamental principle that discovery gave title to those who made it. He just extracted that, left that out. So what that is, however, if you go into that, that's the premise that they always have to return to, because they have to explain away the original free and independent existence of our nations and peoples. And that was Marshall's acknowledgement of that original free, and Chief Justice John Marshall's acknowledgement of that original free and independent existence by saying their rights to complete sovereignty as independent nations. He's talking about the original free and independent existence as nations and peoples were necessarily diminished. Those rights were diminished. Well, that word diminished goes with the word reduced in the papal bull, ac barbari nationis deprimantur, and barbarous nations be reduced. And reduced means diminished, made lesser, a lesser amount, lesser quantity, that sort of thing, lesser rights, you name it. And so these types of techniques that are being used are so subtle, and the average person is so unlikely, the average non-lawyer is so likely to go into this kind of nuance and detail in the court rulings that it never really gets discussed. And if you try to bring in lawyers, my experience has been to be, if people could please mute themselves, that'd be really wonderful. Thank you so much. I'm generally greeted by silence. You know, that people don't, these attorneys don't care to discuss the things that I'm talking about. So anyway, that's perhaps a good enough summary of some of the information that I have with regard to the so-called doctrine of discovery. I'm saying so-called now because I want to call into question the focus on the word discovery. I feel that we've been disserved, and certainly I've been a key part of that by mistakenly placing too much focus on the word discovery, because it's not about the discovery, it's about the intent and the claim of a right, the intent to establish domination and the claim of a right of domination. That's really where our focus ought to be, in my view, and figuring out how to challenge that premise, challenge their premise. Right, we have to have a viewpoint looking from the shore out at those colonizing ships coming in toward our own ancestors, not a perspective that's on the ship coming toward our own. If you hear somebody's a native person presenting who says our founding fathers, our fourth president, or that kind of thing, it's a pretty sure bet that they're on the ship coming toward our own ancestors and not the other way around. So that part of our effort is to, I think, free our minds of a lot of the that we've been subjected to, and figuring out how we can do a much more effective job of explaining all the information to our people, but also responding to the domination system in a more effective manner. So maybe I'll leave it there, folks. And I thank you very much, Mike, for extending the invitation. And I don't know how people want to handle it as far as questions, or maybe that'll be done at the end. I don't know, but I'll wait and hear how that will be handled on this call. So
Steve,
thank you. Yes.
I and Charmaine, Russ, we were sent an agenda by Mike, and we just went over the agenda. But what we're looking at is we're going to have a break at 1:35 to 1:40 for purposes of health. However, since we got a little bit started and we went a little bit over on the time allocated for Steve, I suggest that we go ahead and proceed. And if you have questions for Steve or other comments, we'll put that at the end, if you don't mind.
That's fine.
What I would like to do now is just to go ahead and pass over the second section of the agenda, which was the follow-up on the preliminary study. And the reason I'm saying that is because Steve mentioned it in his conversation right now. And it doesn't make sense to do a follow-up at this Zoom level with these folks unless everybody has gone through that preliminary study at least once or twice, hopefully more. Because it takes a lot of study to get to this level of what Steve's breaking down for us, no? So instead of doing all that, at this time, going through the follow-up, I'm going to simply suggest one simple question for our group here on the Zoom, and then I'm going to pass it over to Charmaine for her to pick it up from there, no? And this is the question. If these relatives, not if, these relatives came here, they got here, they were not invited, am I right? They weren't invited to come here and take over and colonize and dominate and kill 215 kids. And were they invited? They were never invited to do any of that. But when they got here, they were greeted with certain understandings about how it was supposed to be between us and them, between them and us. And neither us were to dominate them, and neither they were to dominate us. That was never the agreement. And that agreement is still alive right there in that fire. We don't got no domination agreement with them. There's none at all. It doesn't exist. It's a lie. Yet, how many of us here on this call have the same identity as an original nation, that we're not dominated by that system? Because, and I'm asked Steve to give a quick comment on the imagery, Steve, of the yoke as a symbol of what you're speaking about in terms of the terminology, right? The symbol of the yoke, please, Steve, give us a quick, like a
quickly
version of the yoke.
Yeah.
And then Charmaine, if you could pick it up after that.
Yeah, and sorry for going over my time. I should have been more.
Had to get out. Go ahead.
The freedom, let freedom ring, the Liberty Bell. What's above the bell? The yoke. And sub is under, and jugare means to yoke, and subjugare means to subjugate, meaning to dominate. And so the Liberty Bell is the ringing of their freedom, their so-called freedom and liberty to have their system of domination as the American Empire or the Canadian Empire, or the Dominion of Canada, or the British Crown, or whatever the heck it is. So yeah.
Bring that forward, Steve, because everybody who's on this call should take a look at that and see how those systems of meaning and sound and imagery are systematically being used to try to subject us and dominate us to their way of thinking and their way of being, no, which is not ours, no. So to get to that point in the conversation, I'm going to ask you, Charmaine, if you wouldn't mind, go ahead and help us out with what you got to share for us today. This is a follow-up of that first call that we had a couple of weeks ago. And if you want to mention what we went through there, that would be good, but I'll leave it up to you now. And then Russ, you'll follow after that, if that's okay.
I just wanted to say something that I recently heard. You know, many of us have been writing to the Pope, sending messages to the Pope, and even there was a march in Italy a few years ago where Indigenous nations, representatives from Indigenous nations took letters, and my letter was taken to the Pope, and I have a picture of this young man handing him the letter asking him to rescind the Doctrines of Discovery. What I just recently heard, this is just an addition, it's what I recently heard was that the Pope has ordered all the priests, all the nuns, all the religious to now read the Doctrines of Discovery. We can look at that as a good way, or we can look at that as a bad way. Are they going to try to reintroduce this again, or are they looking at, what did we do? What did we do so horrible? They tried to kill off, and they did kill off hundreds of millions of us in the Western Hemisphere. And I'm not even including Africa in that. So I'm supposed to be talking about the Universal Declaration on Human Rights and the United Nations Declaration on the Rights of Indigenous Peoples. Now, a couple weeks ago when I was on, because I did an analysis. I was at the debates at the UN, and I did an analysis of the Declaration on the Rights of Indigenous Peoples. And here it is. This is the book that I put out. It came out in 2013. And so if anyway, if you want to look at it, and I go through it word by word by word, and that's what we talked about the last time. Mike kept asking me, are Indigenous peoples excluded from the Universal Declaration on Human Rights? Yes, we are. We are excluded. And why? Why should we be excluded? And it has to do with something that Stephen just brought out, how we are savages, we are pagans, we are Saracens, we are all these things that we were not Christian. But the other part was we also were not human. And so many of the colonizing states are the colonizing governments, and the one I know the best is the United States. Because we were not human, then when the settlers came through, we were considered no different than a buffalo, a deer, an antelope, a rabbit, something to eat, and they did. There is another book this one came out in the 70s. It's by Dick Gregory, and it's called No More Lies. It happens to have more information in there about the black people and what happened to them, but it also has a lot of information in here about us. And this is where I first learned about the settlers when they came through were cannibals. And when they couldn't kill a deer or kill something else, they would kill an Indian. And so we were not considered human beings. And if it's hard to find this book, No More Lies by Dick Gregory, came out in the 70s, but it's a really good book to read because it exposes more about what happened to us, to all of the Indigenous people, and even to today, why we are not considered in the Universal Declaration on Human Rights and why we needed to have our own declaration is because even under American law, to this day, I am not considered a human being. I am not considered a person because I refuse to give up my loyalty, my membership, who I am as a member of the Oceti. They call us the Great Sioux Nation, and I refuse to give up who I am as a member of the Great Sioux Nation. And because I refuse to give that up, then I am not considered a human being. I'm not considered a human being or a person under American law. Standing Bear v. Crook, that's the case. If you look at it and if you really read it, Standing Bear expatriated from his nation. And so then the American judge said he was a person now. He could participate in American law as a person. But if he had not expatriated from his own nation, then he would not be considered a person, a human being. And so this idea why we are not part of the Universal Declaration on Human Rights, because how many of these colonizing governments still do not consider us to be human beings, to be a person? It wasn't just reading this book, No More Lies by Dick Gregory. Not just reading this book. There was an elder that I talked to once about this, about the cannibalism that was practiced by the settlers against us because we were considered food. And he said, yes, he remembers that when he was a little boy, a real little boy, and they used to go off the res, they go off of the prisoner of war camp at 344 Pine Ridge Reservation, and they would travel down into Nebraska so they could help pick potatoes during the harvest time. And he said when he was a little boy, he remembered this old grandma who used to always say, oh, I wish I had me an Indian. I wish I had me an Indian, because she was one of the cannibal settlers that first settled in northwestern Nebraska. And they used to eat us. They considered us to be game. We were not human beings. We were considered to be animals. So that's one of the things I know about the Universal Declaration on Human Rights. And so the other question he asked is, why is there a need for UNDRIP? Because now that they have done what they have done, the forced assimilation, the colonization, now that they have tried to change us all into white people. And again, my condolences to all of our relatives up there in Canada for this newfound gravesite of these children in British Columbia. And I am so sorry. I am going to be releasing shortly. It's a screenplay I wrote 3 years ago about one of the residential schools that is here in Rapid City where I live. And these are stories that were told to me by elders who are all gone now, but by elders who were children at the Rapid City Indian School. And anyway, I'll be releasing that soon. So if you want a copy, email me, cwhiteface@gmail.com, and I will send you a copy of that. But there is a need for UNDRIP. If they want us to, they think they have assimilated us all into their cultures, their way of life, that we consider our relatives, which they call resources, that we have changed our value system so much that we no longer remember who we are. But there are still many of us, and I'm very thankful that there are still many young people who are learning, who their parents have taught them and their grandparents have taught them, so that they keep remembering who they are. And so there were 3 versions of it, and that's the sad part. The first version came out in 1994. In my book, I talk about it, and it's in here. The whole thing is in here. All 3 versions that I'm going to be talking about are in here. The first version is called the original text, and that was the original subcommission text was passed in 1994, and that is the only one that Indigenous people approved. The original subcommission text that was passed in 1994, and that is the only one that we approved, Indigenous people approved. And then in 2006, the Human Rights Council passed another version. Now, this second version that the Human Rights Council passed in 2006 was the one that was presented by the chairman of the working group on the declaration. It was on the debates on the declaration, because after the 1994 text was passed, then the countries with the English-speaking countries particularly were the ones who said, no, there have to be more debates about this. Well, it had been going on for 10 years, from 1984 until 1994. And now it was being ready to be sent to the General Assembly for their final approval. But the English-speaking states said no. And I know from myself that Article 36 of the original text was the reason why the United States did not want the original text to be approved at the General Assembly, because Article 36 gave us an international forum place to go for resolution of our treaty disagreement, our treaty suppression by the United States. And so they did not want that Article 36 to pass. And so they pushed it off into more debates. And then there was never any agreement. It had to be by consensus. It had to be by consensus between the Indigenous people and the nation states. We had to reach a consensus on this, and there was never any consensus on the whole thing. There was only consensus on about 4 of the articles. There were only, I think it was, I forget, only 9 preambular paragraphs in the Universal Declaration, and I forget now. I had it marked and I put my book down and I lost my place. But anyway, the Universal Declaration on Human Rights is a declaration, but the United Nations Declaration on the Rights of Indigenous Peoples is not. In many of the articles, there's 46 articles in the Declaration on the Rights of Indigenous Peoples there are only 30 articles in the Universal Declaration on Human Rights. So there's 16 more supposed rights that we have on the Declaration on the Rights of Indigenous People. But a lot of those articles are mandates to the states. A lot of those articles are mandates to the states, which means that they are laws, there are regulations to the states. And that's why when this was happening, when I was debating at the UN on this, I would bring that up. This is a mandate to the state. It is not a right for Indigenous people. And I write about it in this book. The same thing, I say the same thing. This is a mandate to the state. And who is going to enforce this? Who's going to make the United States do anything? Who can do that? Are all the other states in the United Nations going to make the United States live up to a mandate? I'd like to see that. They're not going to. And so there was a second one that was passed in 2006 at the Human Rights Council, and that was the chairman's text. Luis Chavez, he was the chairperson for the working group on the draft declaration, and he was the one that submitted his version to the Human Rights Council in 2006, and that's what they passed. But the African Union said no, they wanted to make more changes to the Declaration on the Rights of Indigenous Peoples. Now, why didn't they bring up these changes during all the years of the debates? The African Union had the opportunity to do it while we were there. But no, they waited until after. No more Indigenous people were going to be there to debate anything. And then the African Union, and they brought up 9 more changes. They made 9 more changes into the original declaration. And then finally, the General Assembly passed a version in 2007. So that's why I have said, no, 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 no. Canada, you cannot pass that bill C-15 because it's based on a lie. It's based on a lie. It says that the Declaration on the Rights of Indigenous Peoples was approved by Indigenous peoples, and that's the lie. No, it was not approved by Indigenous peoples. It was changed. It was changed many, many times. There's only 4 articles in there that were approved by Indigenous peoples. And no, Article 46, that was, no. That's probably the biggest one that gives the most power to the colonizing governments. So I'm gonna let this go back to you guys now, and if anybody has questions or whatever, we can do that again later at the end.
Charmaine,
Yes.
I would like to take a quick pause before we pass it over to Russ.
Mhm.
And I'm going to ask you to review once more. We know that you picked up your assignment. You didn't do it on your own, it's just because you decided to show up in Geneva one day, right? You got sent to Geneva by a very specific treaty council. Please explain the position, responsibility you have, and the 1894 Sioux Nation Treaty Council has in terms of this international work.
Okay.
And also, please give us one more time for emphasis and clarity. What is the wording of the original Article 36? So that everybody on the Zoom call can come away from this call knowing they got the correct information at least one time. Go ahead, Charmaine, and then we'll pass it to Russ.
Zumilawabaga Emachiapie. I should have said that in the beginning. My name is a little wise one who makes a mark. I am Oglala Tituan or Chetishakoi. In 1994, when they pushed this off into the working group, when the United States pushed this off into the working group, we already had representatives 100 years before that. In 1894, one of our headmen, he had gone to these residential schools and he had learned how to read and write English. And when he came back, in order for the people not to forget about our 1868 treaty with the United States, then he more and more people gathered together with him, and they start teaching, not just themselves, but their children, their grandchildren, on down through the generations, about the Fort Laramie Treaty of 1868 and about the uh, Treaty of 1851. But the 1868 was our last treaty. And so in 1894, the Sioux Nation Treaty Council was formed. At that time, if you talked about the treaty, then you were either jailed, you were killed, or you were sent to a place called Canton, South Dakota, on the eastern side of the state. And where they would, it was called the Indian Insane Asylum, and they would do lobotomies on our people without anesthesia. How many people were killed there, I don't know. But I mean, it's just because it's so hard for me to talk about. So when I was born in 1947, my grandmother was teaching me about the treaty. And she told me not to tell anybody, not to tell my parents, otherwise they wouldn't let me stay with her. I'm the oldest grandchild, and in our culture, the oldest grandchild is often either given to or allowed to stay with the grandparents, and I was. And so I learned about the treaty from my grandmother. Since I can remember, I've always known about the treaty. I didn't know that the majority of my nation, the people, did not know about the treaty. And so when I get in my 40s, I started writing. I was writing a column for the Rapid City Journal, and a weekly column. And I'm really proud of that editor that let me write, because today, no, they would not accept my columns. The new editors there would not accept them, but at that time they did. And oftentimes I wrote about the treaty, and I wrote about how we came from a separate nation, our own sovereign nation, and that we lived on POW camps. Those were the reservations. And the elders saw this, they read this. And the spokesperson before me, and now I am the spokesperson for the 1894 Treaty Council, and the spokesperson before me was cutting out all of my columns and hanging them up on his walls in his house. And so in 1994, the American diplomats in the men's room, and it was overheard by one of our representatives. His name was Garfield Grassrope, and he was in there, but he was in a stall, and so they didn't know he was in there. And they said that our people were too uneducated, and they could not debate with them, and that's why they wanted the declaration pushed off into a working group where they would have to debate, because they said my elders, the spokesperson before me, was not educated and could not debate with the United States diplomats. But they didn't know he was in there, and he heard them say this. And so he waited till they left. And when they left, then he came out, and he told Tony Blackfeather and Garfield Grassrope, they were the two representatives before me. And Tony was a spokesperson before me. And they came home, and they told the people, and they told the people, there is someone who is educated and who could argue with them. And that was me. Because of all of my writing I did about the treaty and about who we are as a nation. And that's one of the things I don't like about the Declaration, is that it only mentions peoples. They did not on purpose. They kept out the word nations. It's like Steve said, words, it's little words, and they kept out the word nations. And we all are members of different nations that have been almost totally destroyed. And so in 1994, then, when Tony and Garfield came back from Geneva, and they gave their report to the Treaty Council, and they told the Treaty Council that I could debate for them. And so then they appointed me to take over, to work with those two guys, and then to take over whenever Tony passed away. And he passed away in 2004. And since then I have been the spokesperson for the Sioux Nation, the 1894 Sioux Nation Treaty Council, But what people don't know is that the Great Sioux Nation, the Oceti was a matriarchy. Our women, our older grandmother women like me, great grandmas, we were the leaders and the men protected us. And so 100 years later, I was appointed as a spokesperson. Again, coming back into the circle was finished now. We're coming back into where the women again have to speak up, and we are the leaders for our nations again. And we are for survival, and that's why women are always the leaders. So thank you, Tupac, for asking me.
Charmaine, Russ, I'm gonna pass it to you right now, but if you don't mind, I'm gonna go ahead and read to put it on the record and have it recorded. The original Article 36 that was put in Charmaine's hands for her to make sure was not altered, modified, or eliminated in the negotiation that was supposed to go forward to the General Assembly. That's what I understand, no, Charmaine?
Right,
If I'm
right.
wrong, you can correct me.
The
This is
only
the
reason
original-
why we went, the
This is
only
what-
reason why we went to the UN and why I was told no changes on the original was Article 36. That was the only reason why we were there, was for Article 36.
The point being that this is still the position today, regardless of what everything that has happened, everything else that has been done, this is still the position today. This is Article 36 as originally submitted. Indigenous peoples have the right to the recognition, observance, and enforcement of treaties, agreements, and other constructive arrangements concluded with states or their successors according to the original spirit and intent, and to have states honor and respect such treaties, agreements, and other constructive arrangements. The second sentence, there's only two sentences. Conflicts and disputes which cannot be otherwise settled should be submitted to competent international bodies agreed to by all parties concerned. When we take a takeaway from this Zoom meeting today, this is one of the most essential fundamental pieces of information that we have to take away and have this conversation with our folks at home, in our communities and in our nations, because you're hearing Charmaine give you the report right now. She was there at the hunger fast where this was betrayed. And what happened since then. But this is being brought back again, and it's been brought to your attention through this mechanism for the purposes of following up and following through of why, as Charmaine said, why do we go to the United Nations in the first place? We were sent to get the treaties instituted as part of the body of international law in a multilateral context where the states don't dominate and don't dictate to us what our relationship is with them. That's a treaty. A treaty is between nations. You don't have treaties with your own citizens. That was the purpose. We didn't get sent to get a declaration. We got a declaration. Okay, fine. We didn't get sent to get an expert mechanism. There's one there now. We didn't get sent to get a special rapporteur. Those things are there, but that's not why we were sent. And unless we get this one established, those instruments and those mechanisms are going to be used against us, which is really what we've seen. I'm going to close with that. That's my opinion. I'm going to pass it over to Russ, and he can give us the update of how what we're talking about is being implemented in the Canada and the C-15. Go ahead, Russ. Can you unmute yourself?
Thanks, Tupac. And thanks, Charmaine and Steve, for your explanations. That really helps set the context for, the background to what federal government is trying to push through the Canadian Parliament right now, which is called the United Nations Declaration of the Rights of Indigenous Peoples Act, the UNDRIP Act. That bill, they only did an engagement 6 weeks before introducing that bill into the House of Commons in December 20th, 2020. And most of the people they engaged with are federally funded Indigenous advocacy or political organizations. They did not talk to the 600 plus First Nation communities across Canada, the members of those communities, about this bill. And Canada's position is, well, Romeo Saganash's bill, he was a Cree member of Parliament for the New Democratic Party. he had an individual members bill previously in the House of Commons called Bill 262. And what the federal government is, they said they made improvements to it. They used Romeo's bill as the floor. And that's why they didn't really need extensive discussions, because they said Romeo traveled the country about talking about his bill. And this bill, you know, since they use Romeo's bill as the floor, they call it, and made improvements to it, that the 6-week engagement process with Indigenous organizations, mainly provinces and industry associations, and that was good enough to introduce this bill into the House of Commons. Now, our Indigenous activist networks, the Defenders of the Land, I Don't Know More, and the Truth Before Reconciliation campaigns, we did a full analysis of Bill C-15 after it was introduced. And we had lawyers who have constitutional and international experience who were part of the analysis, and we're confident in our full analysis, which is available online, as to why we recommended rejecting the bill. I recently appeared before the Senate Committee on Aboriginal Peoples, who was doing a pre-study of Bill C-15. And on behalf of the Indigenous Activist Networks, I told them that in our view, you cannot separate the analysis of Bill C-15 from the stealth and deception that the Trudeau government has undertaken for the last 6 years in making the major policy, legislative, and structural changes to the federal government that they've done in a top-down manner, using the national Indigenous organizations, the Assembly of First Nations, the Métis National Council, the Inuit Teppers at Kanatami. Those are the 3 key groups, they call it, plus the modern treaty groups, are what the federal government, which the Minister of Justice, David Lametti, calls the key groups that they talk to in developing Bill C-15. Now, C-15 is not a very long law or bill. There's 7 sections to it. Most of the people who are supporting it on the Indigenous side, including Romeo Saganash, the Grand Council of the Crees of Quebec, other modern treaty groups, they are all pointing to the flowery preamble. And they're saying, oh, you know, there's a section in the preamble that says that notions of superiority are rejected. And they're saying that's where the doctrine of discovery is rejected, or domination, as Steve points out, are rejected, is in the preamble. But, you know, we've talked to lawyers, and the lawyers have said, yes, it's true. The preamble does have interpretive weight, but it does not, unless it's in the main sections of the bill, it does not have full legal weight. And that's what we've been saying, is that section 1, you know, refers to the UNDRIP Act. It doesn't say the adoption of the UNDRIP Act or the implementation of the UNDRIP Act. Bill C-15 does not implement the UN Declaration. Even the 2007 version that Charmaine's talking about, that Indigenous peoples didn't agree to, excuse me, it doesn't implement that. What the bill says is, you know, first of all, that Indigenous peoples are defined under Section 35 of the Constitution, which refers to Aboriginal peoples of Canada, which are Indians, Inuit, and Métis of Canada, meaning the boundary of the state is what they're entrenching. The international definition of Indigenous peoples is being domesticated into Canadian law within the borders of the Canadian state. Even though there was just a Supreme Court decision called the Desautels decision about a Snight who was a hunter. They declared the Snights extinct in British Columbia, and he lives in Colville, Washington, on the reservation there, but he's of Snight ancestry, and he continued to hunt in British Columbia. The Supreme Court ruled that he has a right to hunt there, even though he's, quote, not a Canadian citizen or a resident. He had the right to hunt elk in Snight traditional territory. So that calls into question that section of the bill, the definition, the Canadian domestic definition of Indigenous peoples. Even their own Supreme Court has said that that Indigenous persons outside of peoples outside of the Canadian state have rights in what is now Canada. That's one thing. Section 2 of Bill C-15 also refers to the rights of Indigenous peoples, and it's based on Section 35 of the Constitution Act 1982. Now, the Constitution Act 1982, that's Canada's new constitution. The Queen signed it into law on April 17th, 1982. There was a Section 37 in that new constitution. And Section 37 said that within 1 year of that new constitution becoming law, Prime Minister had to call a meeting, a First Minister's Conference of the leaders of the national Aboriginal organizations, the premiers of the provinces, and the leaders of the territorial governments, you know, the Northwest Territories and the Yukon, to a meeting, to the purpose of which was to identify and define the meaning of Aboriginal treaty rights in Section 35. So the Aboriginal treaty rights in Section 35 was supposed to be due to a political agreement, but they had constitutional talks in the 80s. Those talks ended in failure. The courts took over in 1990 and started defining Section 35. So it was meant to be a political agreement as to the meaning of Aboriginal treaty rights. But, you know, the leaders of the Crown governments ran out the clock, and in 1987, the last First Ministers' Conference was held, and it failed to reach an agreement on the meaning of Aboriginal treaty rights. The main issue they talked about was self-government, whether it was an inherent right or a conditional right, depending on agreements. So that's what they're entrenching in Section 2 of Bill C-15, is all of the case law over the last 30 years defining Section 35. And that case law is all based heavily on the Doctrine of Discovery, or the Doctrine of Domination, as Steve puts it. And that's what's being entrenched in Bill C-15 under the laws of Canada, is their domestic definition of Section 35, which they claim will be used as a framework to implement the UN Declaration through Section 6 of the Bill C-15, which is an action plan. So now before the Senate committee, whenever they're questioned about all of these outstanding questions and omissions and things like a definition of free, prior, informed consent, all of these issues that the right wing are raising, like the conservatives and industry representatives, they're saying, oh, we can discuss that in the action plan, which is to be developed. After Bill C-15 becomes law, the action plan will be defined, and in consultation and coordination with Indigenous peoples. Well, that's the language they've used from the beginning. When the federal government says in consultation and coordination with Indigenous peoples, for the last 6 years, that's meant this top-down secretive approach with the 3 national Indigenous organizations and the modern treaty groups. Those are the key groups, as they said, that they helped develop Bill C-15, and that's who they're going to, they've already said before the Senate committee that they're already discussing the action plan even before Bill C-15 becomes law. So it's not going to be our peoples who are the rights holders that are going to be involved in all of this. It's going to come down from the top down. So in the action plan, if they say, okay, we're going to develop new legislation to implement the UN Declaration or new policies, it's all going to be through that action plan process, which will be, you know, involving the national Indigenous organizations, not peoples on the ground. And that's what Bill C-15 is. It's implementing, and both the federal government and the Assembly of First Nations have manipulated the introduction and the passage of this bill through Parliament. Perry Bellegarde, the AFN National Chief, says that AFN has a mandate to support Bill C-15, but actually the mandate he's relying on is from 2019. And in December of 2020, AFN had a special Chiefs Assembly. And I know for a fact that there was a resolution on Bill C-15, which called for a process to be developed within AFN to get views from First Nations across Canada to propose amendments, not to accept Bill C-15 as it is, but to seek fundamental amendments to Bill C-15 through a process developed through AFN. Well, the Assembly of First Nations manipulated the process and wouldn't allow that resolution to hit the floor for debate because, well, the National Chief wants to rely on this 2019 resolution saying the resolution says that AFN is supposed to engage with the federal government to develop a bill to implement the UN declaration that uses Bill 262, Romeo's bill, as the floor. And that's what Perry Bellegarde is saying Bill C-15 is. It's based on what Bill 262, Romeo Saganash's bill, proposed. But they would not allow a debate on the floor on Bill C-15 on that resolution. They're using the 2019 AFN resolution, which is very vague, to say they have a mandate to support Bill C-15. And the federal government has done the same. They have not introduced any amendments, even though witnesses came forward in the House of Commons committee asking for amendments to be made to Bill C-15. They only tinkered with minor amendments to the whereases and some cosmetic changes in the main part of the bill. But for example, they did not add in a formal repudiation of the Doctrine of Discovery in Section 2 of Bill C-15, which is on the rights of Indigenous peoples. That would show that they were serious about, changing things to conform to recognizing Indigenous rights. But they didn't do that. They're forcing the bill through as is. And it looks like the Senate committee is wrapping up. And if they don't propose amendments to Bill C-15 to send back to the House of Commons, then it's quite likely that the Senate will have a full vote when the committee sends if the committee sends the Bill C-15 back to the full Senate for a vote, and if it passes a vote in the Senate, then it's quite likely that Bill C-15 will become federal law by June of 2021, before they have their recess in mid-June for the summer. So it looks like they've been fast tracking Bill C-15, manipulating it through the Assembly First Nations, and of course the Métis and the Inuit organizations as well. And our people, they're doing this in the middle of a global pandemic. Most of our people don't even know this is happening. They haven't even been able to have a discussion about the UN declaration, let alone Bill C-15, which purports to be a framework for implementing UNDRIP through an action plan, which is not yet defined, which will only be defined after this Bill C-15 becomes law. And the federal government has full discretion in controlling the development of that action plan. So it's a very one-sided, unfair process that the Trudeau government is pushing through on Bill C-15, and it's very close to becoming federal law now. And what I told the committee when I appeared before the Senate Committee on Aboriginal Peoples is we're going to be recommending to, if Bill C-15 becomes law, we're recommending to Indigenous communities and nations that they prepare plans to resist this on the ground, the implementation of Bill C-15 and this so-called action plan on the ground. So that's my my update on Bill C-15. Thank you.
Okay, Russ, Mike, if you're available, Russ just set the stage for the battle that's going on right now in Canada, and he's also giving us the signal that there's actions to be taken. Before we get to that point, Mike, I'm gonna ask you to step in here to take your place in the agenda. A clarification, if you would like to consider. Russ mentioned it's going to become law. The term law has been used throughout this Zoom, the law of this, the law of that. Yet, is this really law or is it legaloid? You know, you have a phone and they call it the Android, right? Because it represents a human an Android, no? Represents a legal system. But if it was legal, there would be justice, there would be harmony. Now, the point being, colonization is illegal. It always has been illegal against our laws. Barely they made it illegal in their system in 1960. But even in their system, colonization is illegal. And everything what you're hearing here are evidences of the illegal act of colonization and genocide. Genocide is also illegal, not just bad, it's illegal. Colonization isn't just bad, it's illegal. So they push a C-15 legislation through as an illegal act of colonization. It has to be challenged as a legaloid piece of legislation, not a system that produces law. That's an opinion. But to get to that point, Mike, if you're available to pick it up, Are you there, Mike? Can you unmute your mic? Is Mike still there? Trying to catch up with Mike. Mike, can you unmute your mic? I don't know if you can hear him or not. Anybody?
Okay, can you hear me?
Yes, sir.
I'm not good at this technology, but thank you very much to
Got it. You
Stephen,
got it.
Tupac, and Charmaine, and Russ. Now, I put on what Sharon had given to us, the international definition of on Indigenous people, and and I just want to say that that I'm learning quite a bit, and I want to mention one person here, Kevin Buffalo. He has some of his students joining us, and that's a good thing for me. But anyway, this is not my my spot. I wanted to give time to the participants to ask the questions of the presenters, and we'll do that now.
Okay, Mike.
Go ahead.
Okay, Mike. Go. We're going to ask the participants to try to. We don't know how this technology works that well, but if you could help us out on your side by raising your question, raise your hand, and then unmute your mic. And then if you can also write your question in the chat box, we can try to get an answer to you, if not today, at some other point. We're about half an hour left in the Zoom, so it's open now for conversation and questions and comments. Brief though. It's open.
Oh, bonjour.
Bonjour.
Bonjour, everybody. Especially you, Ross, what you just said there. I didn't catch it from the beginning, but I just got from the middle to the end. My quick question is this, I put it on the chat. Can there be a statement describing what you just shared with us? Because we have an opportunity to talk to our youth council, our women's council, our traditional knowledge council. And I think this is so important to understand that, you know, this is kind of like blindly has an effect on us, and I'm not anti-chief or anything, but I am concerned about our national bodies, even our provincial bodies. But anyway, that's my question.
Well, I did do a statement to the Senate Committee on Aboriginal Peoples, which is, I think it's a 4-pager. That kind of gives our position on Bill C-15 and what's wrong with it and what we're recommending, like I just mentioned about resisting its implementation should it become law. That statement I think I can post that on here. And people can take that and use that to share with their members.
Me which?
Russ and Mr. White Spotted Horse. We just put it on the chat, the booklet that was published by our brother Arthur Manuel, Getting Organized booklet, and some of the other base documents that are the reference for this Zoom call. We're putting them on the chat, but as a follow-up and a follow-through to this session, this is already the second session, we are suggesting for the end of the call that we consider opening it up for the next time to a webinar where we could bring more people in, that they will just be listening in. And these kind of statements can be made public, no? From whatever might result after this session. However, since we are looking as a priority, the situation of the C-15 in Canada, we would ask of you all, Russ, the Isle No More Network, the Defenders of the Land and the Truth Committee to take the lead on that. I'm calling for the webinar as the next session after we've done these two today, no? And we'll back you up from our side on this down here, no? That's a suggestion. But the documents are on the chat. And if you send us your email, send it to Mike, and we'll make sure you get all the information that's being brought forward today. More comment or question is open. Go ahead, David. David,
Yes, good morning. I'm speaking from Tucson, Arizona. I was going to pose a question to all of you. You know, all the individuals who have been appointed as rapporteurs, having attended the permanent forum twice. The question was going to be holding these rapporteurs accountable for going back to Charmaine's presentation. Has that ever been addressed to all these individuals have been in those positions as rapporteurs on the question that you talked about, Charmaine?
Well, you mean about Article 36?
Based
Or
on your
what
three,
question are you talking about?
what you shared from the very beginning.
Oh,
Yes, going back
Uh-huh.
to, I believe you said
That-
1994. Was that
right,
1994?
right.
That was the question that
1990.
was holding these individuals who have been rapporteurs even to this day, where we now have a new rapporteur. Don't know exactly if he's going to be holding any regional meetings, which the former rapporteur James Anaya did hold here in the United States. But going back to my question, I guess that would be holding these individuals. What would you say holding these individuals to make that very clear at the United Nations based on your presentation this morning?
Over the years and when at the UN, and we would talk about, different ones of us would talk about what is the UN going to do, because it puts them in a bind, because there were two committees, the Working Group on Indigenous Populations and the Subcommission on the Elimination of Racial Discrimination and the Protection of Minorities. They already approved that. They already approved the original declaration. So then to have a totally different one approved by the General Assembly, what does that do to the original? So your question is good. It's really good. A lot of people have talked about this. I don't know, holding those individual rapporteurs, or even at the permanent forum or the expert mechanism on Indigenous people, it's been really difficult, because how I see all of those things is it would be to the General Assembly. We would have to go. We should all go together to the General Assembly. This is what our people did in 1977 when it very first started out, is they went to the whole UN. And that's what we would have to go, is to the General Assembly and say, you are making a real confusing mess within your own system, because we only support the 1994 one. You have two committees that supported this 1994 one. And now all of a sudden, years later, the General Assembly passes a totally different one. We would have to go to the General Assembly that meets in New York in September and bring this out then. That would be a way to publicly bring it out. And then, because these rapporteurs and the permanent forum and all of them, to me, they have no teeth. They have no teeth. They have no way to get this what you're asking about. They have no way to get that to the ones that can do something, and that's the General Assembly. So if standing out front, with protest signs or what, I don't know. But as representatives from nations, we need to keep pushing it. We need to keep pushing that.
I say that it's because here in Tucson, he is you may be familiar with him. His name is Robert Williams. Teaches here at the University of Arizona Law School as a program, and so he's considered an international attorney, and he's given many presentations on the Declaration. It just seems to me that, and I've heard it more than once, that the Declaration has no teeth and it's been watered down back in 2007. And so these individuals who are giving these presentations, they are also in the academia, but they're also individuals who are part of these NGOs who are also using the Declaration to give presentations and training. And I'm not even sure if they're even aware of what you spoke about. And so I go back to the reason why I say this is because Tupac was the one that gave me that information. And so I, have your book. And then it's just clear that I've just never heard that. So I don't know if you'd have any comments on that, but that's kind of like how I see it and what have you. Thank you.
When I started writing the book, it was really the report I was going to give to the people, my people here, my nation. The report I was going to give to my nation, but as I wrote it, and it was so huge, it developed into the book. I'm surprised that there are not more Indigenous representatives that were there. I'm surprised nobody else has written a book about this, about what really actually happened. I'm really surprised about that. And as far as I know, I'm the only one that wrote about it from an Indigenous perspective. And it was just for me, I have to tell the truth, and I have to tell my people what happened, and I have to tell them, especially Article 36, because that's where we were sent, so that we could get a seat at the table and we could get our treaty resolution finally resolved. I see so many things wrong with the colonization and with the United States violating our treaty. They violate parts of it, but other parts they don't. How can you do that? You can't. And so I wish more people knew about my book, now that I know that I'm the only one that did this, because then maybe these academics then would give. I know that there are some places, though, the University of Colorado, they were teaching it in their law school. I know Sharon Venn, she tried to give many of my books to other people to wake them up to what actually happened. And I know also in Australia, there's a professor, a law professor there, Irene Watson, who also uses my book in her classes. So the English speaking ones, yes, they became in academia, a little bit, tiny bit in academia, became aware of it. And so now it has been translated into Spanish, and Tupac is writing the foreword or the introduction into the Spanish version. And we're hoping that will come out very soon, in a month or two. But yes, more of these. If you tell this professor, this Robert Williams, I'll send him a copy of my book. I will send him. And they're having to do now, my publisher is having to do a second reprint as more and more people become aware of it. So yes, I would gladly send him a copy of my book.
Charmaine,
To open him up.
Charmaine, David's question leads me to ask Russ. First of all, for the whole crew on the call, there's like 34 participants. The Spanish version of Charmaine's book, we plan to publish it on August the 13th. August the 13th. August the 13th of this year marks the 500th anniversary precisely of when the Spaniards came into Mexico and took apart the Confederacy that was standing there from times of immemorial. So the Spanish version of the book is going to come out on August the 13th, according to the plan. And this is important for David to hear, because a lot of his nation, the Otham Nation folks, they're in the South. They also speak, besides their language, they speak Spanish. They don't speak English. They don't read English. So this is the next phase to get the message out. But Russ, to David's question, one of the parts of that answer to answer David is that all of these people that are involved in the UN have bought into the systematic use of words and phrases to keep Indigenous self-determination boxed up in the constitutional frameworks of Canada, the US, Mexico, Guatemala, you name it. And they did that by putting in place that system-wide action plan that came out of that high-level plenary meeting, which our brother Art Manuel denounced, and he said, this should be canceled. You should never do this. So Russ, give us a little picture of how that high-level plenary meeting played into what we're talking about across the continent, across the world, and what you got going there in Canada. Go ahead, Russ.
Thanks, Tupac. I think that's a very important point. We've been talking about the domestication of UNDRIP and the fact that it's the wrong version of UNDRIP and all of that. But what we haven't talked about yet is the politics at the United Nations and how they've, it's kind of like, in each of our countries, we know that we have people that work with the government who are collaborating with the government, not with our nations. The same thing is happening at the United Nations. And in 2019, the United Nations held what they called a United Nations high-level plenary meeting. They also called it a World Conference on Indigenous Peoples, which it wasn't, because it was basically a 2-day meeting. And normally a World Conference at the United Nations is a week-long affair, and it focuses on one subject. But in preparation for this 2014 high-level United Nations plenary meeting, there was a meeting in Alta, Norway, hosted by the Sami. And they brought in thousands, well, maybe a couple of thousand or less Indigenous peoples from all the regions of the world. And it was to discuss recommendations to state governments in what is now known as the Alta Outcome Document, because it was held in Alta, Norway. And there were some good recommendations. There was a North American Indigenous caucus there. And we had to work with the other caucuses from the Arctic and, the Pacific caucus, the Asian caucus, all these different regions of the world, Africa, to agree on wording of recommendations to be sent to the United Nations in preparation for this United Nations high-level plenary meeting, which they also called a World Conference on Indigenous Peoples. But after we had that meeting in Alta, Norway in 2013, in January of 2014, there was a meeting of the North American Indigenous Peoples Caucus in Kamloops, BC. Not far from that residential school where they discovered that mass grave of 215 children recently. And at that Kamloops meeting of the North American Indigenous Peoples Caucus, we were getting updates from representatives who were sitting on these various committees in preparation for this 2014 high-level plenary meeting. And they were telling us that Indigenous peoples had no real role in holding that meeting, not even co-chairing it, that it was going to be the United Nations, the president of the General Assembly that was going to chair the meeting. And even though they were talking about, implementing the UN Declaration, in preparation for this high-level plenary meeting, Indigenous peoples were not included. And in fact, you had to be invited as an Indigenous representative. You had to be invited by the state government to attend that high-level plenary. Otherwise, you could not get access. You would not get status to get in. And we discussed it at that North American Indigenous Peoples Caucus in January 2014. And we called for the meeting to be boycotted, because we said if the United Nations itself and the state governments were not going to include Indigenous peoples in co-chairing and having a role in holding this high-level plenary, the so-called World Conference on Indigenous Peoples, then we should boycott it, because it's a false meeting. You know, it's the state government still maintaining control over us, not even accommodating us to jointly, you know, hold the meeting. So we put out a public call from the North American Indigenous Peoples Caucus to boycott it. But what happened was within North America, the establishment organizations like the Assembly of First Nations in Canada and the National Congress of American Indians in the United States, and some of the tribal governments in the United States and band councils in Canada, all said that they were going to go to the meeting. And so they worked with the Canadian government to attend, and the United States government. And of course, other governments around the world did the same thing with their Indigenous peoples. And they held that World Conference on Indigenous Peoples, which they call a United Nations high-level plenary meeting. And there's an outcome document that came out in 2014. And I think I have that document. I think I can share that. They did not mention self-determination in that document once. They did talk about free, prior, informed consent. Canada at the time did not agree with that report, but in the outcome document of the high-level plenary meeting, and this is what's going on across. This is what set the stage to what's happening now in Canada and around the world. Is governments committed to implement the United Nations Declaration on the Rights of Indigenous Peoples through national action plans of their state governments. And that's what Canada is saying they're doing with Bill C-15, is that the action plan that's going to be developed out of Bill C-15 after it becomes law is going to be the action plan called for at that 2014 high-level plenary meeting to implement the UN Declaration. But you know, I would argue that in Canada, they already have an action plan they worked on for the past 6 years, and that's what they're going to implement through Bill C-15. They have a self-government policy. They have land claims policies. Canada's already said that they don't have to reinvent the wheel. That's how they're going to define the UN Declaration in Canada. So they're all saying it's action plans. And Canada is scheduled to appear before the Committee for the Elimination of Racial Discrimination to give a periodic report this November. And you can bet that Canada is going to go there saying, we've passed Bill C-15, we're implementing the UN Declaration through the development of an action plan. And they're going to trot out their good little Indigenous representatives that are going to go with them and say, yes, Canada is doing that. Probably the Assembly of First Nations, the Métis National Council, the Inuit Kanatami. You know, so that the whole UN, and also as Tupac mentioned, they also, to take control of the Indigenous issues, they developed a SWAT strategy, system-wide action plan. And that's available too. They have a written plan. And that's how come the United Nations Permanent Forum on Indigenous Issues is basically contained. You can go there and raise issues, but now, you know, they're being referred to these United Nations agencies, and they're just sidelining our issues within the United Nations bureaucracy. So, you know, not only do we have these problems within the states that we're residing in, the United States and Canada, and them manipulating everything, there's a whole another level of manipulation at the United Nations that we need to be aware of. And unfortunately, many of our people aren't aware of these things. And, you know, they think the United Nations, they call it, you know, an international one world government and all that kind of thing. So there's a lot of misunderstandings of the politics, the global politics even going on and where our issues fit in the global politics or don't fit. So that's something, and I would say the North American Indigenous Peoples Caucus pretty much blew up in 2014 over this issue, because we haven't had a what we called NAPIC meeting since then, because of the disagreements over that United Nations high-level plenary meeting and how they were interpreting and manipulating, responding to the UN Declaration on the Rights of Indigenous Peoples.
Russ and Charmaine, Mike, I hope you're still here. We got 10 minutes left to allow us for a closing prayer. So I'm going to go ahead and suggest that we go ahead and open it up again for more comments or questions, but recognize we're coming to the tail end of our session. So it's open right now for any comment or question.
Kiwenu Abskomako. Nin, Nishnabe. AKA George Monroe. I have a question for Charmaine. Hello?
Go for it. We got you. Go ahead.
Yeah, this NARF in the United States, Native American Rights Fund,
Mhm.
the Colorado Law and the University of put out a toolkit in the United States, and a lot of these nations are implementing their own laws regarding the Declaration in their own language. So I was wondering if any of these, it's a very good book. It's a tribal implementation toolkit from Colorado Law, and if we can have some kind of representation here in Canada, this toolkit is very excellent in writing in all the different nations the resolutions they're putting forward regarding the UN Declaration and human rights. So I think it's you know, that we should have this toolkit for our people here in Canada. This is from I got it from LA. So I mean, I was on a conference call regarding UN Declaration a couple of months ago, and they just sent me the toolkit. It's a lot of information there, and a lot of these nations are converting the UN Declaration, their own language and their own customs and their own laws regarding the Declaration. So that's my question I was asking Charmaine.
What's your question? I never heard about this, so I don't know what this is about. So they're converting, you mean a lot of indigenous nations are putting the declaration into their own languages? Hello?
Repeat the question. Can you repeat the question?
Yeah, the question is,
Hello?
We don't hear you, Andre. Repeat your question, please.
can you hear me?
We hear you now. Go ahead.
Okay, my question is this tribal toolkit from Colorado Law and LA Law School law students that's put this toolkit together, and a lot of nations in the United States are using this toolkit to use the Declaration and put it in their own customs and languages, different nations. There's quite a few nations in here, and I think we need to have this toolkit, and our people can use it here in Canada because we're still North America. So I mean, it's a lot of information that our people should have. A lot of our people don't even have that little booklet, the Declaration of Indigenous Rights, or they don't even know about our treaties. So I mean, a lot of information here has been withheld in Canada. Our people don't know about, and we need to wake up the people and get them to the table.
Mhm, mhm.
Thank you.
I'm hoping, well, I'm concerned that this toolkit is using the final declaration that was passed, the 2007 declaration, and not the 1994 declaration. That would be my concern. I never heard about this. I will look into this.
Your name is mentioned in the toolkit.
Pardon? Excuse me?
Your name is also mentioned in the toolkit, in that booklet.
My name is as a consultant in that booklet?
I guess, I don't know, regarding the declaration, the book, I guess. James and I is the dean at the LA Law School, was moving this in Colorado law. So I mean, I just got it a couple of days ago. I've been going through it. It's very interesting. And there's a lot of information in here regarding nations. And what happens in the United States happens in Canada. It's no difference. We're still North American. Thank you.
Thank you.
A quick comment to what we just heard. It seems to be that this is a conversation of a critical nature, this Zoom conversation. And the first step is to setting up our own criteria. What do we mean by what things mean? What does it mean to have a rights? What does it mean to have a responsibility? What does it mean to be a nation in our own light and in our own right with our own laws? And if we have that understanding, then we know that we don't need their declaration to act responsibly as nations in our own light, in our own right, in our own laws, in our own land. So the fundamental question in terms of our criteria to address the rest of it is, are we willing to accept the concept that our rights are delegated to us by the settlers, by the settler states, by their constitution, by Canada, by the US, by Mexico, by Guatemala? If we accept that, then we're going to fall right into that system-wide action plan. But the beginning of that plan is what Charmaine brings out in her book, the version that was adopted in 2007. Unless we question that and challenge it, we don't have traction to address the fundamental issue, which is our rights were bestowed upon our nations by Creator, by the creation. Our responsibilities to our territories precede all of that. They can't be dominated by that. So to get to that point, Russ is calling for acts of resistance, acts of rebellion, acts of regeneration of our nationhood beyond those domination, colonizing, and genocidal mechanisms, no? So what I'd like to do is suggest, we got 5 more minutes, pass it back to Charmaine, to Steve, to Russ and Mike, and if you guys can give us your closing words, and we'll start to we'll start to end the session. Go ahead, Charmaine, Steve, and then Russ.
I just want to thank everybody for listening and for the questions. And I want to ask for prayers for all of us, for every one of our nations and all of our generations to come, for protection, for good health, just those 2 things. But we need to do this because we are really, really under attack. We don't know it, but we are really, all of us, all over the world, all Indigenous peoples right now are under attack by the colonizing states. So I ask for prayers because we have more power through our prayers than anything. So thank you. And thank you for listening to me.
Where's Steve?
Yeah, good to be with all of you. And there's so much to cover in a very short time. So I think we gave it a good go today. And just last thing I'll say is that no document is self-interpreting. And the UN Declaration on the Rights of Indigenous Peoples that folks are interpreting into their own languages and so forth, if that is what's going on, as was indicated, there's so much to it as far as how does the United States interpret that document. They interpret it consistent with US law, which means consistent with the doctrine of Christian discovery and domination. That's their framework to interpret the UN Declaration. We need to address that. And so I thank you very much for all of your time and attention. Thanks for having me.
Russ, you're on mute.
I want to thank also everybody for listening to that, and thanks for being invited to this conversation. Thanks for Mike to getting it started. Definitely in Canada, we have particular issues that we're facing because the Trudeau government's been very good at stealth and deception, making it seem like he's doing good things when he's actually doing the opposite. And like Charmaine says, I pray that we all can find our way through this around the world and get our freedom and liberty back from the domination that's been imposed on us. Yawa.
No way. Okay, Mike, there it is. You've seen it. Everybody's been.
James could, all I'll say is one of my uncles went to Geneva at the World Court. Stephen talks about the language of domination. And my uncle went over there for one letter, the letter S. We are more than people. We are a peoples. We got a long way to go, but we are already there too. So somebody say a prayer, and thank you to everybody participating. Thank you to the presenters. Ajia.
Tupac, can you close us with a prayer?
I think Mike is gonna do the prayer, Charmaine.
Oh, okay.
Go ahead, Mike.
You want me to say the closing prayer?
Yes, sir.
Okay. Mandum na gibnaska go wega skopta Isaac. Knop magunag ni Janstik. Nikenda moat huga gizmina tot en mkamoat en mitjumina moat en yen kyogiot. Yes go gwet nan nakum gonna gagi shots, mina gonna gagi pishots. Kakanagan en snam. Wait gis tot maidan skinan. Mina kekitian. Ajia. Okay, that's it. Thank you very much.
Okay, everybody, we're gonna ask you to keep in contact with Russ, with Mike. And the folks in the north, we're gonna prioritize your fight there with the C-15. Whatever we could do to back you up and help you out, let us know. Consider having a webinar to take it to that next level, and we'll work with you on that. So with that, we're gonna go ahead and close. You guys have a good day. Take care of yourselves. Many blessings, many happiness. Ayo.
Wanishi, thank you.
Aquí es, going out.
Hey,
Thank you,
¿cómo
Brett.
estás?